car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Welcome into the attorneys again this week. We're super excited to have you with us this week. Thank you for being with us for the last 11 years. It's been our great privilege at Hollis, Wright to be able to answer legal-related questions for issues that you face in your life. The show is always better, as we say each week, when people participate and ask questions. This is an opportunity for you to have a free, off-air, confidential conversation with an attorney. Throughout the show, you'll see a scroll on the bottom of the screen that has the 844 Law Talk number that you can always call. You can also text us. There'll be a text number there for you. And in addition, we're available on social media throughout the week and happy to answer questions you may have related to legal-related issues in your life for free. So the lawyers will be standing by tonight to answer those things. Stephen Bulgarella is with us tonight to talk about bankruptcy. We're very excited to have you on, first of all, on a topic that our firm knows nothing about. We go to experts like you in these issues, so you will be the most educated person on this set today without question. So we're super excited to have you on, and thank you for coming on the show.
Absolutely. I'm glad to be here.
Absolutely. So tell me a little bit about how you got involved in this. I know traditionally you had kind of worked on the defense side of the bar, and you worked your way into this, and kind of explain it a little bit.
Sure. So I actually went to law school with the idea that I wanted to practice in the criminal law field. And over time, I just came to find that my passion was in bankruptcy and being able to help individuals and consumers work their way out of issues that impact their their life and their family.
So a lot of the bankruptcy world is a unique world to what we do on the civil side. You've got your own court system. It's kind of uniquely different at the federal level. Have you always done bankruptcy as a lawyer, even when you started over on the defense side of things, or did you just kind of work your way over? Because I know you started your practice over the last year or so.
Sure. So I've been in practice since 2015. I started out working in a small office that did specialize in consumer bankruptcy matters, so mainly filing Chapter 7s, 13s, and 11s, again, on behalf of individuals and families. I then spent about 5 years on the creditor side representing banks and mortgage lenders, so Fannie Mae, Freddie Mac, et cetera, which was a really great opportunity for me to learn the law from both sides. But I always knew that ultimately I'd like to get back to representing individuals and helping people sort of get their financial lives back on track. So for the past year or so, I've been practicing solo at the law office of Stephen Bulgarella.
Well, congratulations.
Thank you so much.
For being able to do that out on your own. That's a fun process. All right, let's delve into the actual topic itself. I know that bankruptcy can be intimidating to people. We bring guests like yourself on to be able to work through these issues to explain to people it's not as intimidating and you need to just have a lawyer on your side. Talk a little bit about when someone comes in for an initial consultation, they probably have a lot of questions of if they even qualify for bankruptcy. How do you just kind of generally start that process when you sit down with them?
Sure. So I like to sit down with a client and ask them, first and foremost, what brings them in. If I can get an idea of what type of debt issues they have, I can have a better idea of what options are available to them in the bankruptcy system. So for individuals and families, there are two main types of bankruptcy, a Chapter 7 and a Chapter 13. Chapter 7 we often call a liquidation. It's a good opportunity for people who have fallen behind on what I'll refer to as junk debt. So medical bills, credit cards, payday loans, maybe they had a car that was repossessed. They need an opportunity to shed all this bad debt and get themselves a fresh start. And so for people like that, we'll put them into a Chapter 7. We'll have other people who have come into our office that have fallen behind on their car or fallen behind on their home. They want to keep this asset, but they need an opportunity to get caught up and to prevent a foreclosure or repossession. There's another type of bankruptcy called Chapter 13. We often refer to it as a reorganization, and that's what's best for those individuals. But to answer your question, again, it's always best just to get in touch with the bankruptcy attorney. Most, if not all of them, will do a free consultation for you. So again, come into the office, spend 30 minutes or an hour with you, and we can give you a better idea of if you qualify for bankruptcy, and if so, what options are available.
And I know we get a lot of questions texted on these shows about, well, I'm struggling right now to pay my bills. I think I'm eligible for bankruptcy. How am I even going to pay a lawyer to assist me? Generally, a lot of that is kind of handled through the bankruptcy court. Can you explain a little bit about that? Because that's one thing that really should not hold consumers back.
Absolutely, that's true. So the Chapter 13 bankruptcy, which we call a reorganization, this is an opportunity for people to get caught up on their cars, get caught up on a home loan, while also shedding that bad debt that we mentioned earlier. So in those instances, the attorney fee can actually be paid through the court. So some attorneys will ask for a small down payment, but many will file your case for free, and again, they'll be reimbursed through the court. So if you are interested in bankruptcy but are concerned that you might not have the money to pay an attorney up front, it's still going to be worth your time to get in contact with an attorney and sort of work through the conversation.
That's a great point. And I often say on this show that I find that clients, once they understand the process, even on my side of how they're going to be represented, they feel a lot more comfortable about dealing with lawyers on a daily basis, answering questions, those types of things. Hey, talk with us just for a second about, you went through kind of Chapter 7, Chapter 13, but a lot of the issues that people are concerned about, will I lose my house? Will I lose my car? I need my car to go to work. I do still have a job. Are they guaranteed to lose those things during a bankruptcy?
That's a great question, and probably the most common question that I come across. The answer is absolutely not. If you wish to keep an asset in a bankruptcy case, we can sign what's called a reaffirmation agreement with the creditor that says that you want that debt to survive the case.
So ultimately, they have the ability to keep that house and also potentially keep the car.
If they want to.
Okay. And those may be the problems, though, right?
Exactly.
And that's what you've got to kind of walk them through. We also get a lot of questions about a spouse. I don't want to damage both of us. My spouse does not have the financial issues that I have. Can they file individually and not impact the spouse?
Another great question, and the answer is that they can file individually. A bankruptcy can be filed, a couple can file bankruptcy together, a family can file together, or if one spouse has sort of a unique and separate issue, then they can file an individual bankruptcy case for themselves.
You're, by the way, super educated, I can already tell, and you're the type of person that our folks need to be able to get to, so I'm glad that you're on tonight. We're going to go out to a commercial break real quick, and when we come back, I do want to talk about several issues, credit being one of them, because we get a lot of questions about what happens to my credit. If I file bankruptcy, is my credit ruined forever? We'll talk about that. We're going to go to our first commercial break. As always, we're here. You can call us at 844-LAW-TALK. You can also text us throughout the show. The show operates better when you've got questions and you present them to us. So please feel free to do that, to have a free, off-air, confidential conversation. We'll be back in just a minute with the attorneys segment 2. I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off-air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys. Welcome back to the attorneys. We're so excited to have you back with us. We'll be here today to answer questions related to bankruptcy. And if you've got legal related questions related to things off topic, we have lawyers standing by right now for a free off-air confidential conversation. You can call us as always at 844-LAW-TALK, and you also can text us as you need to. The text number is on the screen throughout the night. Stephen, when we went off to break, I teased the break that I wanted to talk a little bit about credit because it's an issue that people are concerned about it in today's world. And generally the question comes like this. If I file bankruptcy, I feel like I'm ruined from a credit perspective for years to come. Can you just kind of unwrap that a little bit for us?
Absolutely, and that's certainly a big concern for people who are considering filing bankruptcy. Generally, when I sit down with them, I'll do my best to remind them that if you're in the position that you're considering filing bankruptcy, and we ran your credit report, I don't think it's going to be great at that time. So I would look at bankruptcy as an opportunity to rebuild your credit over the long term. First and foremost, filing bankruptcy doesn't mean that you will never be creditworthy again. I have a lot of clients who, if they put the work in, are able to get a car loan at a decent rate within 12 months of coming out of a bankruptcy case. And I've had some clients that have been eligible for a mortgage at a reasonable rate within 18 months coming out of a bankruptcy case. So no, filing a bankruptcy case doesn't mean that, that you won't have the opportunity to finance assets in the future.
How do you advise people in general terms when they come in whether they even qualify? Because I know that there are plenty of people that you deal with that don't even qualify for bankruptcy in their current situation based on income and whatnot. How do you go through that process to explain to that person?
So this is one that will oftentimes require us to put some pen to paper. In order to qualify for bankruptcy, there's sort of a two-part test. First and foremost, we look at the average median income for your family size within the state. So if you're below median income, you're going to qualify for bankruptcy, generally in whatever chapter you'd like to file. If your family income size is above the median, that doesn't necessarily mean that you're not going to qualify. There's sort of a second part of the test that's called a means test that takes in a few more factors, related to your budget, your monthly income, et cetera. And again, depending on what you have going on in your financial life, you may still qualify.
Yeah, and that was one of the issues I was going to ask you about is, if someone runs up such significant debt and their income doesn't just justify the ability to pay that, does that also weigh into the equation at times?
It does, and so those will be some of the factors. What are your monthly expenses in terms of what you spend on a car, on a mortgage, if you pay child support, even if you have stuff like payday loans that you're required to pay monthly, those would all go into the equation.
There are going to be certain things that certain types of debts one cannot bankrupt against. Is that fair?
That is the case.
And talk just a little bit about that. And I'm not asking for a list of every single thing, but what are some things that you see where you have to advise people, hey, look, this is just not something you're going to be able to bankrupt, but we can file a bankruptcy related to other related issues that may help you in that area?
Sure. So the big one right now is student loans. And so we're hoping to see a change in this in the coming years. But as of right now, you can't file bankruptcy and get a discharge on student loan debt. Similarly, most tax debts, now there are certain tax debts that you actually can discharge in a bankruptcy case, but most of those are going to survive the bankruptcy as well. Earlier I'd mentioned child support. Yeah. Back due child support payments will always survive the bankruptcy as well.
Does someone who is on Social Security disability, do they have the ability to file bankruptcy if necessary? And does that SSDI, can the SSDI be part of a plan in general terms? And I know it's a super unique area of the law, but I just wonder that sometimes.
So we have clients that are on disability and Social Security into our office every week, and they almost certainly qualify. And yes, we can use that Social Security income to fund a Chapter 13 plan. Say, for instance, they've fallen behind on their car and they want to use the bankruptcy case to prevent a foreclosure, or excuse me, to prevent a repossession and allow them to keep the collateral.
And now, Stephen, I know you can't hold a client's hand at every moment. They've got to be responsible if they're in a 13, for example, for paying their plan. If they don't pay their plan, they're going to get an arrearage with their own plan and can be kicked out of bankruptcy. Is that fair?
That's true, yes. So in a Chapter 13 reorganization, what we'll often do is we'll put your mortgage payment and your car payment into a single payment that you'll pay to the Chapter 13 trustee. Like we mentioned earlier, the attorney fee will also be paid through that single payment as well. So it's your responsibility over the 3 to 5 year plan term to make it's typically a monthly payment. Sometimes we can break it down into a weekly payment if the client prefers. But you're correct, Josh. If they fail to make that payment, then the trustee would file a motion to dismiss, and that case would get tossed out pretty quickly.
Talk to us just for a minute about kind of an important topic. We talked about credit. Credit rebuilding. I would actually think that a lot of your advice to individuals is this is your opportunity to start your credit rebuilding from here forward. Credit rebuilding is a big topic in today's world. We see commercials on it all the time. Is it something that you kind of lead, guide, and direct people through?
It absolutely is, because it's our goal to get you sort of heading back in the right direction in terms of your finances. So part one is going to be shedding the bad debt, but part two is going to be rebuilding your credit post-bankruptcy. And there are several strategies that we can take to make that possible. The biggest which is assisting clients in getting what's called a secured credit account with banks. That can make a huge difference in sort of rebuilding your credit in the months following a bankruptcy case. But absolutely, we do our best to educate our clients on the steps that they need to take to rebuild their credit so they can get back up there into the upper 6s and the 700s where they need to be.
When we come back, I want to talk a little bit about kind of trends and things that you're seeing in the bankruptcy world that maybe you can provide some advice to people that are watching. We're going to step away for our final break of the show. Of course, the show is always better when people participate by calling, texting their questions for a free, off-air, confidential conversation. We're going to be here for another segment. And we would love to have your questions come in to the extent that you've got a question related to this topic of bankruptcy or any legal related topic. We'll be right back. I'm Josh Wright with the law firm of Hollis, Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WBTN 13. Welcome back into The Attorneys. Tonight we're talking about bankruptcy. As always, the show is much better if you get your questions in to the extent you want to call at 844-LAW-TALK. The number is right there on your screen. We also have a text number if you want to text your question in for a free, off-air, confidential conversation with an attorney that they are there ready to answer your questions tonight. Stephen, when we went to break, I wanted to talk a little bit about trends. And I know during COVID, some of the numbers were down and maybe they're coming back up now. Just talk a little bit about that and kind of how you assess and diagnose all that.
Sure. So in 2020 and 2021, we saw the volume of bankruptcy filings decrease significantly. Unfortunately, here in 2022, with inflation on the rise and the economy where it is, we're seeing a pretty steady increase, again, relative to those years prior in 2020 and 2021.
You know, one of the issues we get a lot is I have liens against me. And as you know, liens come in all sorts of shapes, colors, and sizes. Am I able to file bankruptcy and reduce my lien or eliminate my lien? Can you talk just for a minute about that?
Absolutely. And so judgment liens are one of the big issues that bring people into my office. And the short answer is generally yes. We can use a Chapter 7 or a Chapter 13 bankruptcy case to shed a lien that's tied to your property, again, due to a judgment or due to a personal loan or a payday loan that wasn't able to be paid.
And then let's talk a little bit about garnishments. I'm assuming people come to you for the very first time right after they have a garnishment and say, hey, look, I can't earn the income that I thought I was going to anymore. You know, I may need to file bankruptcy. Garnishments are a big part of probably what you face when you're in the bankruptcy world. How do you advise people related to that?
Sure. So we're all doing our best to get by right now. And when an individual or a family looks at their paycheck and realizes they're now receiving 25% less due to a garnishment, it's going to be tough to make your basic monthly payments, much less make an effort at paying back some of the debt and medical bills, et cetera, that we face. A garnishment can be stopped immediately by filing a bankruptcy case, and many individuals don't realize that actually if you file a bankruptcy case, say today, you have the opportunity in bankruptcy to claw back any funds that have been garnished in the 90 days prior to the filing. So yes, if you're facing a garnishment due to a judgment or anything else, getting in touch with a bankruptcy attorney and talking through your options would be a great idea.
You raise a great point. So often as lawyers, we gloss over concepts that are really important concepts because we just assume everybody understands. I do that in the personal injury world all the time when I'm talking with clients, and I recognize, hey, I need to actually boil it down into simpler terms to make sure that person understands exactly what the point is here. A bankruptcy is a stop. It eliminates people's ability to continue to call the debtor and try and collect against them. Talk for a moment about that, because that's an important concept that you and I probably gloss over and don't really think about, but the person sitting on the couch right now that's being hammered by bill collectors, by trying to collect a lien, garnishments, etc., you have the ability to stop that instantaneously, don't you?
That's correct. So at the moment that the bankruptcy case is filed, what's called an automatic stay is imposed over the debtor's estate. The automatic stay prevents creditors from making any attempt to collect the debt against the individual. If they have any questions or any inquiries about the debt from that point forward, they have to reach out to the individual's attorney. And so earlier we talked about the stress that comes with debt and being behind on your finances, being harassed by bill collectors on the phone, by mail, even stuff like calling your job. All that stuff has to stop immediately upon the filing of the bankruptcy case.
And I think that's an important concept, right? There's a mental and emotional side to
Absolutely.
Struggling financially and needing to talk with a lawyer. What's your general advice, Stephen, just about, I know people are intimidated sometimes to talk to lawyers. We try and make this show as non-intimidating as possible by allowing them to call for free at no cost and ask questions related to real-world issues they may face. What's your advice on the bankruptcy side about the importance of coming to talk to a lawyer for that free initial conversation and consultation, just to get advice on, because I always feel better when someone that knows something more than I do gives me advice on here's how you can manage this situation. To me, I feel more comfortable about how I'm going to manage it moving forward because I got advice from somebody that knew what they're talking about. I'm assuming that's kind of an important part of your role.
It really is so important. There's something about falling into significant debt that just pushes some people to sort of become a recluse and deal with it internally. Nobody wants to talk to their friends about having fallen behind on debt. Nobody wants to admit or feel like they failed. And that's why it's important to recognize, number one, that debt is not failure. It's one of those things that comes from bad luck in life, loss of job, loss of income, divorce, et cetera. So yeah, speaking with a bankruptcy attorney about the rights that you have and the options that are available to you is incredibly important. And again, in almost all situations, it's going to be free.
Yeah. Medical bills, one of the biggest culprits for getting people sent to bankruptcy, you think? Mm-hmm. Health insurance is a super important component. And with lawsuits, if someone has a civil lawsuit, there are times that you have to list that lawsuit as an asset on their estate in order to make sure that that lawsuit is properly protected. It's just something that we deal with.
That's true. Disclosure of your entire financial situation is going to be imperative in filing bankruptcy. But again, as long as you're honest with the trustee, you really don't have much to worry about.
You are super educated on this topic. I'm so glad that we brought you because you're able to really help boil it down into simplistic terms. Thank you for being on the show today.
Well, thank you for having me.
And thank you for watching another version of The Attorneys. We're here each Sunday night, and we're also here during the week to answer questions that may impact you in your life. Thank you for watching The Attorneys, and we'll see you next week right here.
Thanks for watching The Attorneys, sponsored by Hollis Wright.